बिस्मिल्लाहिर्रहमानिर्रहीम अस्सलातु वस्सलामु अलैका या रसूलल्लाह वस्सलामु अलैका या हबीबल्लाह। प्यारे व्यूअर्स, आज 3 दिन के बाद मैं आपके साथ आपके पास हाज़िर हुआ हूँ। उसकी वजह यह थी कि मेरा अकाउंट हैंग हो गया था। आज मेरा अकाउंट रिकवर हुआ है तो मैं आपके पास हाज़िर हूँ। और मेरी आप तमाम दोस्तों से गुजारिश है कि मैं माज़रत खा हूँ कि 3 दिन मेरी गैर हाज़िरी रही। और साथ में ये भी मेरी गुजारिश है कि मेरे इस चैनल को जो नए दोस्त देखने वाले आए हैं वो सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुंच सके। आज हम पढ़ेंगे सेक्शन 236। When it is debatable what offence has been committed, if single act or series of act is of such a nature that it is debatable which of several offences the fact which can be proved well constitute, the accused may be charged with having committed all or any of such offences, and any number of such charges may be tried at once, or they may be charged in the alternative with having committed some one of the said offences. अब आते हैं इलस्ट्रेशन की तरफ, इसमें सही आप लोग समझ सकेंगे। A is accused of an act which may amount to theft or receiving stolen property or criminal branches of trust or cheating. He may be charged with theft, receiving stolen property, criminal branch of trust and cheating, or he may be charged with having committed theft or receiving stolen property or criminal branch of trust or cheating. B states on oath before the magistrate that he saw B hit C with a club before the session court. A states on oath that B never hit C. A may be charged in the alternative and convicted of intentionally giving false evidence, although it cannot be proved which of these contradictory statements was false. अब आते हैं, ये उम्मीद है आपको समझ आ गया होगा। सेक्शन 237 की तरफ चलते हैं। When a person is charged with one offense, he can be convicted of another. Number 1, if in the case mentioned in section 236 the accused is charged with one offense and it appears in evidence that he committed a different offense for which he might have been charged under the provisions of that section, he may be convicted of the offense which he is shown to have committed, although he was not charged with it. अब illustration की तरफ आते हैं। It is A is charged with theft. He appears that he committed the offense of criminal branch of trust or that of receiving stolen goods. He may be convicted of criminal branch of trust or of receiving stolen goods, as the case may be, through he was not charged with such offences. Section 238. When offence proved include in offence charged. Number 1, when a person is charged with an offence consisting of several particulars, a combination of some only of which constitutes a complete minor offence, and such combination is proved, but the remaining of particulars are not proved. He may be convicted of the minor offence though he was not charged with it. Number two, when a person is charged with an offense and facts are proved which reduced it to a minor offense, he may be convicted of the minor offense although he is not charged with it. When a person is charged with an offense, he may be convicted of an attempt to commit such offense although the attempt is not separately charged. Number three, nothing in this section shall be deemed to authorize a conviction of any offense referred to in section 198 or section 199 when no complaint has been made as required by that section. A is illustration. A is charged under section 407 the Pakistan Penal Code with criminal branch of trust in respect of property entrusted to him as a carrier. It appears that he did not commit criminal branch of trust under section 406 in respect of the property but that it was not entrusted to him as a carrier. He may be convicted of criminal branch of trust under section 406. B. A is charged under section 325 of the Pakistan Penal Code with causing grievous hurt. He proves that he acted on grave and sudden provocation. He may be convicted under section 335 of that code. अब चलते हैं सेक्शन 239 की तरफ। सेक्शन 239 क्या कहता है? व्हाट पर्सन्स मे बी चार्ज jointly? The following persons may be charged and tried together, namely: A. Persons accused of the same offense committed in the courses of the same transaction. B. Persons accused of an offense and persons accused of abetment or of an attempt to commit such offense. C. Persons accused of more than one offense of the same kind within the meaning of section 334 committed by them jointly within the period of 12 months. D. Persons accused of different offences committed in the course of the same transaction. E. Persons accused of an offense which includes theft, extortion, or criminal misappropriation, and persons accused of receiving or retaining or assisting in the disposal or concealment of property possession of which is alleged to have been transferred by any such offense committed by first named person, or of abetment of or attempting to commit any such last named offense. F. Person accused of offences under section 411 and 414 of the Pakistan Penal Code or either of those sections is respect of stolen property, the possession of which has been transferred by one offense, and G. Person accused of an offense under chapter 11 of the Pakistan Penal Code relating to counterfeit coin, and persons accused of any other offense under the said chapters relating to the same coin, or of abetment of or attempting to commit any such offense. and the provisions contained in the former part of this chapter shall so far as may be applied to all such charges. Section 240 Withdrawal of remaining charges on conviction on one of several charges when a charge containing more heads than one is framed against the same person and when a convicted has been had on one or more of them, the complainant of the officer conducting the prosecution may, with the consent of the court, withdraw the remaining charge or charges or the court of its own accord may stay the inquiry into a trial of such charges. Such withdrawal shall have the effect of an acquittal on such charge or charges, unless the convictions be set aside, in which case the said court, subject to the order of the court setting aside the conviction, may proceed with the inquiry into or a trial of the charge or charges. So withdrawal. प्यारे व्यूवर्स, आज तक के लिए बस इतना ही। मिलते हैं अगली वीडियो के साथ इंशाल्लाह कल। तो इजाज़त लेने से पहले मैं आप लोगों से रिक्वेस्ट करूँगा, एक दफ़ा मैं फिर माज़रत ख़्वाह हूँ कि 3 दिन मैं आपके साथ हाज़िर नहीं रहा। उसकी वजह यह थी कि मेरा अकाउंट हैंग हो गया था, बंद हो गया था। आज मेरा अकाउंट रिकवर हुआ है, शुक्र है अल्हम्दुलिल्लाह। तो मैं आपके पास हाज़िर हूँ और मैं अपने तमाम नए आने वाले दोस्तों से गुजारिश करता हूँ कि मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुँच सके। अल्लाह ताला आप सबका हामी और नासिर हो। तब कल तक के लिए मुझे इजाज़त दें। अल्लाह हाफिज़।